From Florida's Space Coast, this is your career.
Welcome to Your Career. I'm Debbie Featherston, your host, and with me is Ed Kinberg, who is partner at Wiederman Malik Law Firm.
Yes, ma'am.
Thank you so much, Ed, for being with me. This is a program I'm excited about. We are going to be talking about legal careers, and specifically in construction and contracting. And I'm just curious, how did you choose construction law as an area of specialty for you?
Well, it goes back a little bit to my Army days. About halfway through my career, I got a little concerned about whether or not I was going to make it from captain to major, and I was in my advanced course. In the military, we go back to school for a year. And so I could have specialized in military justice and gone on the military justice track, but that didn't really give me a good outside training opportunity. Then I found they had this group called Contract Appeals Division that defends complex claims against the United States around the world. So I said, I'll do that instead. So I switched all my courses to contract courses, got into contracts, and did that for 4 years. Most of those were in manufacturing.
Really?
I didn't really have any construction cases back then, a few service cases. But when I got out of the service and moved to Melbourne at the invitation of a good friend of mine who's now a local circuit judge, David Dugan, or the Honorable David Dugan, I realized that a lot of the issues in construction and build-to-print manufacturing, which was what I was doing in the military, are the same. Defective drawings, delays, lack of clarity, all those kinds of things, confusion of contract terms. So it was easy for me to migrate from manufacturing to construction, and plus there was a lot of federal construction. And that's my other specialty, is federal procurement. So I've really got two areas that I work in within the overall field of commercial law, which I generally work in. So it was easy for me to slip into construction because I was already familiar with many of the terminology in it. And I found out I really enjoy construction cases.
Well, what really appeals to you around that whole work in construction?
Being around cool stuff.
Okay, I get that.
You know, and there's a lot of different kinds of construction law, and I do different ranges of it. I do contracts, we do bids and proposals, but what I really like doing is the disputes over whether or not something is being built correctly. And as part of my investigation process, into every case where there's a claim, I go out to the building. And at the time I moved here, there was a lot of stuff going on at Kennedy Space Center that was being contracted out. So there were a lot of claims there just because there was a lot of stuff going on. And so I went out, and one of my claims involved the vehicle assembly building. One of my cases involved the orbiter processing facilities, the news center they were building. Another one was on a launch pad. And I had to go out and actually see what my clients were talking about what the problems were. So I got to go to a lot of cool places. The same thing in manufacturing. In the Army, we always went to the plant. Didn't have to, but I always went to the plant, and I talked to the people that were making the thing to see, or deposed them to see if I could understand the process, because if you don't understand the process, and it's the same in construction and in manufacturing, if you don't understand the process, you can't solve the problem that's driving the two parties apart. So it was a lot of fun, and I like to get out to the field and do stuff.
Very fascinating, you know, being a big space, buff and just, curious myself about things. I would find that quite fascinating as well. Well, I'm just curious, let's take a look at it from a property owner's perspective. What should a property owner know before they actually engage in any kind of a construction contract?
They should first, it depends on what you're doing. The first step in any construction contract is design. And they should have a good idea of what they want to do. And they may want the contractor to hire an architect to bring the design to the table. They may want to do it on their own. But that's always the first aspect. And in the design phase, you need to coordinate with your local building department to see if you can do what you want to do. For example, in many communities, you can't cover up more than 50% of the permeable land with concrete. So if you want to build an addition onto your home, you may have a limit on how big you can make that addition, or you may have to reconfigure part of what's existing. I had a friend of mine that turned his driveway into a timber driveway, so it would be permeable. Could have done pavers too, I don't know why I picked timber. But he could have done pavers because the water will percolate through those things. And then that opened up space in his backyard for him to build a big deck for his pool. So that's the kind of stuff you need to know. If you replace windows, what are the code requirements on windows? A lot of people buy windows that are new, but they're not hurricane windows, and don't realize as part of the permitting process, you also have to have shutters of some kind or preset connectors for plywood panels as part of putting those new windows in, because the windows have to be protected under the code. So if they're just looking at buying the windows and don't think about that, when they go to get the permit, they may be told, well, now you got to add shutters on it. And depending on what you use, it could be a small amount, maybe another 10% for a bunch of plywood, pre-cut. And you have to have the pre-cut plywood. Or if you're going to use hard shutters, you know, metal shutters or plastic shutters, it could cost as much as the windows cost.
Oh, absolutely.
And people don't, people need to check that out before they get into it.
Yeah.
They need to make sure that they have a license, that they're using a licensed contractor. But not only a licensed contractor, but a reputable contractor. And there's a lot of people that just simply do not ask, can I see your license? Or do you have a license? You can go to somebiz.org and find out if their corporation is properly set up in the state of Florida.
Right.
You can go to myfloridalicense.com and see if the company is qualified to do construction. And the reason I say qualified is a company that does construction isn't licensed to do construction, technically. An individual qualifies the company, and he's the contractor of record for that property. You know, in a big organization like Lennar, that person's actually not going to be out there every day. But you can see who the qualifier is and make sure that's all set up. You know, one of the things, kind of a pet peeve of mine, is contractors, to get their license, all go to school. And they have to pass a test, and part of that's a legal test. And one of the requirements in Florida is contractors have to have their license number on everything except small promotional items, pens, ball caps, stuff like that. So if they're giving you an estimate and their license isn't on it, or they're giving you a business card and their license isn't on it, and I'm not saying there aren't a lot of good contractors that don't have their license on it, it's something to question. Why isn't your license number? Are you ashamed of your license number? You know, because to me, a sign of a quality contractor is one that knows what the rules are and complies with those rules. And one of those rules is on your business card and on your estimate forms, and you're going to have your Florida contractor license number, and there's some initials that go in front to tell you whether it's a general contractor or residential or roofing or mechanical or electrical, but you're going to have that on your card because that's what you're required to do. And then before your contractor starts work, you need to make sure that they have a valid workers' compensation policy. But I just type into my Google search engine, or whichever one you use, Florida Workers' Compensation Database, and it brings me to the right place. And I can type in the contractor's name and see, okay, this contractor's got 3 exemptions, and they use more than 3 employees, so they've got workers' compensation for the other people, and those policies are valid and enforced. Or they were valid and enforced at the time they reported it. You never really know. And we have rare cases of contractors buying insurance, showing it to somebody, and then canceling it. It's rare. But it happens. So a lot of times, if you're really being an ultra cautious consumer, you might want to check out those kind of details, because there's all kinds of detailed information you can get. And the workers' compensation database is online. The licenses are available online, and the organization of the structure is available. Their articles of incorporation or their limited liability documents are all online. So for myself, I routinely check those things when a new construction case comes in, whether I'm representing the contractor or the homeowner or the owner. I don't say homeowner. When I talk about homeowner, I'm including homeowners, not just also commercial owners. You check those things out. And that's what I always check out, to make sure the client is properly structured if I'm representing a contractor, to make sure they got all their workers' comp squared away, to make sure they've got everything lined up so that I can move forward with whatever they want or fix whatever needs to be fixed before we get into a big fuss about solving the problem.
What about from the property owner's perspective, being able to check out, you know, references, and what about checking with Better Business Bureau to make certain that there's been good follow-through or examples of workmanship? Are those things that you would advise?
I have mixed feelings about all of those things, because the people that are unhappy complain, and sometimes people that are super happy write comments. And sometimes people are solicited because they're super happy to write comments. So you don't know, especially nowadays, you don't know how reliable. I had a case one time where I found a company was putting their own comments on Angie's List. Just having their friends and families put them on there. So you don't know what you're getting or how that website vets those things or how the BBC vets those things. So you want to talk to past people. But the interesting thing you can do with a contractor is every construction project in the state of Florida, except for state and federal, has to have what's called a notice of commencement. If there's no notice of commencement, and that's an owner responsibility, it's typically filled out by the contractor, but it's something the owner has to sign. When that document is recorded with the county, it lists the name of the owner and the name of the contractor. So you can go to the Brevard Clerk of Court to their official records button. It says official records. It's about 3/4 of the way down the center column, or currently down the center column. It moves from year to year. And you click on official records and you type in the contractor's name, Joe Smith Construction. And you're going to pull up notices of commencement that contractor has filed with the county, and it's going to have the name and address of the owner. And so you could do your own random check if you want to.
Okay.
You don't have to rely on the contractor to find out about past projects that the contractor has done.
Well, that's very
In the commercial world, it's not that significant a problem because there's not that many commercial contractors, and
they're going to be well known.
they're going to be generally well known, but not always.
I'm thinking it's probably the homeowner that's less educated of their role and responsibility.
And particularly after a natural disaster, a major fire or hurricane, which seem to be common in this area, you've got to be real careful. And sometimes the governor will waive rules to let out-of-state contractors come in. But when you do that, and we saw this a lot in 2000, I served as a hurricane mediator for the state once a week during the hurricanes. There's a lot of contractors that come in from out of state that either aren't familiar with Florida building code and don't build it right, or they aren't there to follow up on warranty work, no matter what their warranty says. So you want to make sure that you use, if you can, that you use a local contractor, or if you don't use a local contractor after a disaster, that you at least confirm that this guy really is, or this guy or gal, this company is really a national contractor, and they have a place that you can go to complain.
Okay. Somehow you can connect with them and that they're really reputable.
Yeah.
Yeah, I know that that's been a big concern. I moved here 15 years ago almost from the Midwest, and that was something that I was warned about right away, is contractors here are not always reputable, and they're not always licensed, and so you really need to check them out.
Well, contractors everywhere. That's not a Florida problem. Florida has licensing laws that are more stringent than many states do, but in every state there are contractors that are not reputable, that don't have good follow-through, that won't be in business more than 3 or 4 years, and you know, those kind of things.
Yeah.
So picking a good contractor is a difficult task, and I mean, this goes to con artists in general, and I'm not saying contractors are con artists.
Sure, no.
But the best con artists have the best personalities. So it's really hard to pick out which guy's selling you a good line and which guy's selling you a good product.
So is there anything else that when you're trying to advise someone, or if, in general, if you would just be giving us advice in terms of how do you select a good contractor, any additional thoughts around that or summaries?
In addition to the license number, there's also 2 provisions that are required to be in a construction contract. One's about lien rights, and the other one's about the Construction Industry Recovery Fund. Those are required to be in every contract or attached to every contract. So if you don't have a license, you don't have those 2 documents, you've got a contractor that's not following the rules.
What is a lien right?
The lien rights, I'm glad you brought that up, Debbie, because that's really important to understand. And a lot of people don't understand this, is anyone that provides work on your property to make your property better than it was before, not just maintain it like a grass cutter, but makes your property better than it was before. If you don't pay them, or if they work for a contractor and they follow the rules I'll discuss in a minute, and the contractor doesn't pay them, you are responsible for paying them, and they can put a lien on your property and force the sale of your property. So if you have a direct contract, you know who that person is. And if you get into a dispute with them, then, and don't pay them, they may lien your house, and you've got a lawsuit. And in a construction lien lawsuit, whoever wins can get attorney's fees. So they can be very expensive. And sometimes companies, both contractors and homeowners, use those as swords to try to scare the other side off. I'm not going to pay you, lien my property, and I'll get it all. It doesn't always work. And a lot of people do unadvisable things. I had one case one time where I think the roof was maybe 20 grand, and the homeowner and the contractor got into a $300 dispute. And the homeowner refused to pay any of the 20 grand.
Oh.
And so my client, for 20 grand, had to file a lien. And not only did he win the 19.7 that he was due, we actually won the 300, which was kind of surprising because judges usually want to give something up. But it was so clear that he had no basis for even the little credit that he wanted. So the guy paid the homeowner ended up paying my guy as much in attorney's fees as he paid for the house. Whereas if he had paid my client the money that was actually due, then my client probably would not have pursued a lien because it's very expensive to go through a foreclosure process for $300. So and not all lawyers agree with me on this, but my feeling is if you owe the money, pay the money. Now the only exception to that is if you owe the money, the work was done, but it's substandard, poor work, and you're going to have somebody else come in to do it. You're going to be entitled to credits for it. So until you know what your back charges, we call them, would be against that contractor, then you hold on to an amount of money that you think will cover that. Go out and get bids and proposals and say, okay, to fix this window that you guys messed up is going to be $800, and so I'm holding back $1,000 to be on the safe side.
Yeah.
That then becomes reasonable, because eventually, if the dispute's not resolved, you're going to have to go talk to a judge.
Yeah.
And when you talk to a judge, the most reasonable and realistic side wins. So if you have a good, reasonable explanation for why you didn't make a payment,
Yeah.
or as a contractor, why you didn't do a certain piece of work, if you have a good, reasonable explanation, that your chances of succeeding at trial are significantly increased. But trial is always a wild shot. You never know if you're going to win or lose.
Yeah.
So I would never say anyone's got a definite shot at it.
Right.
But you improve your chances by having good documentation, showing that you communicated something or that you were told something. So like if you want to add like, in commercial or residential, you want to add 4 extra electrical outlets, or you want to add some internet outlets somewhere. And the contractor says, sure, I'll do it at no charge. Shoot him back an email or a note that says, thank you for agreeing to provide these 4 outlets at no charge. I'm sending this email to confirm my understanding. If this is not correct, please let me know.
Yeah.
Because 4 years later, when it gets to the judge is going to see, you sent out that email, there's no record of a response to it, you were the reasonable one in deciding you didn't have to pay for that. So that's how you protect yourself in little bits and pieces as you go through it, is confirm everything. And emails makes it much easier to confirm.
Sure, it does, doesn't it, today?
Yeah. Now, getting back to the lien rights,
Right.
if you have a prime contractor that's hiring subcontractors or bringing supplies, like roofers always bring tile or shingles, right?
Sure.
Those suppliers also have a right to lien your house. And to do that, they have to file a notice to owner within 45 days of the day they first start. In a roofing contract, it's a little difficult because the whole job is over in 3 or 4 days, and if you pay him off, the contractor off, 10 days later, you can get a notice to owner and a lien from the supply company. Very rare for something like that to happen. So you have to wait that 45-day period and see if you get any notices to owner. And then if you do, and you should do this anyway, you need to make sure that when you cut a payment, write a check, that your contractor delivers to you lien releases for anybody whose work or material was incorporated into, work or material was incorporated into that property as of that date. Because that way you're at the end of the day, you've got a defense, and if you were defrauded by a contractor, and it doesn't happen very often, it's pretty rare, but if you were defrauded by a contractor, at least you've got a lien release that says, not from the contractor, but from the subcontractor, that says, I did this. I got this payment.
That's very interesting. I had a situation where I had a pool resurfaced and new.
Excuse me, let me get that clock. I'm going to have to
Yeah, you go right ahead. And tile put around it. And what was interesting is their supplier contacted us to say they hadn't been paid for the materials. Well, we had already paid him, but they had not been paid. Well, there was still some work that he needed to finish, so we were in contact with him, and we hadn't paid him in full, but we said, is this an issue? Do we need to divert part of what we should be paying you and pay them so we don't end up with a lien on our property?
And there are circumstances you can do that in. When you get to that point, you need to talk to an attorney.
Yeah.
And you also, if you do pay somebody directly, you need to get a lien release and at least send a note saying to the contractor, your contract price has been reduced by $5,000 because we were required, we felt we were compelled to make a payment directly to this guy.
Yeah.
But the reality is, unless you've gotten that notice to owner within 45 days of the first day of work, so it's always good to, what time did the tile guy come, what did the cabinet guy come, when did the plumber come, to know what their starting date is, because after that 45 days, they've forfeited their lien rights, but you may not know what that first day is.
Yeah.
So that's important to keep in mind. And then they can record a lien up to 90 days after they complete their work.
Okay.
So contractors that come in at the end of a project, the plumbers, electricians, tile guys, the finishing people, they've got 90 days after they finish their work to file a lien. So your project may be done for a month before you realize that nobody's been paid. But if they provided a notice to owner, then you know that you need to watch out and you need to get a release form. And I'd find out who they are and get a lien release anyway. A lot of contractors don't follow those rules.
Right.
I mean, I can't say that I always follow those rules when I have work done at my house because usually I know my contractors that I'm working with. But, and then, and this is a really rarely followed rule in my experience, is that when the project is finished, this is a law thing, not anything else, this is pure law, is when the contract is finished, the contractor is required to give you what's called a contractor's final affidavit. And that affidavit says, in order to induce you to pay me $20 to wrap up this contract, I'm telling you that all the work has been completed and everybody that's worked for me as a subcontractor or supplier has been paid except the following. And a lot of times you'll see NA in the following.
Yeah.
Legally, your final payment is not due until you get the final affidavit.
Oh, that's something I had no idea about.
Nobody does. Most
Interesting.
contractors don't do it, including contractors that I have used. But
Yeah.
like I said, I know them. I know they're
Yeah.
crossing my fingers and assuming, since I've known them for a long time, they
Yeah,
aren't going to
good
take
luck.
advantage of us. But I
Yeah.
can't guarantee that.
Right.
If I was doing it right, I'd require it. In fact, I had an interesting instance the other day where some young entrepreneur called me, and he's working for an association, and they were delaying payment to him. And so I asked him, "Do you give him a contractor's final affidavit?" He said, "No, I don't know what that is." So I said, "Well, I'm going to block copy it out of the statute. There's a statutory form you have to use."
Okay.
So I said, "You don't need to hire us. I'm going to block right now. If they don't pay you, that's different. But I'm just going to block copy it out of the statute and email it to you, and you give it to him." So he did that, gave it to him, got paid the next day, and they told him, "Well, you obviously know what you're doing, so here's your money." But they may have held on to that money because they didn't have that final affidavit, which gives you, as an owner, a direction, a broader, a better protection.
Right.
Should one of those subcontractors or suppliers come out against you, because now you have a claim against the contractor for giving you a false affidavit. So it's really a really important document.
That is
To me,
very
it's an
good.
important document.
Yeah.
And then the last thing that nobody thinks about is a notice of termination. Technically, when your project is done, there's supposed to be a notice of termination, and once that's recorded, all lieners lose their rights after, I can't tell you the period off the top of my head, but after a certain period of time, all the lieners lose their rights because there was a notice that this project has been finished, and you've got 30, 60 days to
Right.
make any claims before they expire.
Yeah.
During the real estate collapse, there were a lot of construction projects under development, and banks started requiring, even projects that were ongoing,
Right.
if there was like a land development phase and then they were going to start construction, they would require a notice of termination and close out of that phase of the project before they would finance a new phase.
Oh,
That's the only time I've ever seen people really enforce a notice
Yeah.
of termination.
interesting.
But it's technically notice of commencement,
Yep.
notice to owners for subcontractors and suppliers, lien releases as you go through the project, contractor's final affidavit, notice of termination.
Wow.
Those all should be checked. Your contractor should have an active workers' compensation policy or an exemption. They should have commercial general liability insurance. And you can talk to your local building official, and they'll help you
Oh,
with
sure.
a lot of this stuff.
Yeah.
And this is why construction law is so fun, because there's so many little technicalities that people mess up on. And if you like playing with technicalities, you like reading documents, and like me, then it's fun. If you don't like reading documents, it's not a good idea.
Yeah.
But it's fun. The owner, person you think is the owner, is not always the owner.
Yeah.
So every piece of property in the state of Florida has a public record that says who the owner is. So for example, on a residential piece, you may have an irrevocable trust that owns your property. And if you have an irrevocable trust, then that irrevocable trust has to get a notice to owner if there's work done on the property, not you. So it's always important to go back and see who the owner of the property is. Now, if it's a landlord-tenant situation,
Yeah.
The question comes up, well, can I lien a shopping center or part of a shopping center? And the answer is sometimes. Because if the improvements that are done to your little piece are what's called the gist of the lease, the core of the lease, I was really surprised the court actually used the word gist. I like to use that word. Then you may be able to lien their leasehold interest. You don't get the property, but if they've got a 3-year lease, you might be able to take over their leasehold interest if those improvements are the core element of the original lease. I had an issue one time, it worked, but it was kind of a wild shot, is we actually, one of the space companies, this was 20 years ago, so it was not any of the current companies,
Sure.
was rebuilding a pad, commercial for themselves. They had a 50-year lease with the government for the pad. And so we liened their leasehold interest. And they told us we couldn't lien it. We said we could. The court didn't know what to do with it, so they threw us out. But the end result is the government made sure my guy got paid at the end of the day and said anyone that's filed liens, whether they're good liens or bad liens, has to be paid. And personally, I think it was except for the fact that it was on federal property, nobody could access it, whoever bought it, it was a good lien because it was a leasehold interest, not the federal property. But it's always questionable when you go after federal property. The federal property is a whole different ballpark
I would
and
think.
separate rules and
More complicated,
much
I
more
would
too
imagine.
detailed for today.
Yeah. What about a business owner who decides that they're going to lease a piece of property, and they know that right out of the gate they're going to have to do some renovations? Any suggestions about language it should go into the lease, or?
It depends on whether they're making the improvements as part of the lease or making the improvements on their own before the lease.
Got it.
So that makes a big issue. And we can't go into the detail. I can't go into
No,
the
no,
details
no.
of it, but if you're going to lease property and the owner's going to build it out for you,
Yeah.
you need to get the nature of that build out nailed down before you sign the lease, because you want a crystal clear understanding of what's
Right.
going to be done. Other than that, all the same rules about the notice of commencement, the contractors, the notice to owners, the lien releases, all that applies whether it's commercial or residential. In that regard, there's no difference unless there's a bond.
Yeah.
And there's similar procedures for bonds.
Yeah.
But all those same rules apply.
Apply.
Now, what we do, what many lawyers recommend is that if you're going to own a piece of property and lease it out, or lease multiple properties, put them in separate corporations so that if you're selling widgets,
Right.
but you happen to be moving your factory to another place, but you want to keep that property and lease it out to somebody else, create a separate company that owns the leased property, so if something bad happens on that property
You're isolated,
and there's a suit
insulated.
against you, that's not going to affect the rest of your assets.
That's good.
So-
So the layer of insulation there then from
Keep
what you're
your
saying.
primary earning business separate from your secondary earning business so that one doesn't kill the other.
Yeah.
Either way, it can go either way.
Yeah, absolutely. Well, Ed, that's going to have to be the final word. Thank you. A wealth of information. I'm so glad that you have joined us once again. And on behalf of my guest and everyone here on the set of Your Career, thank you for watching. And remember, be career happy.
More information about this program is available online at millermediagroup.org.